Good afternoon, everyone. Welcome to our monthly Dallas Volunteer Attorney Program, CLE. My name is Kristen Salas. I'm one of the mentor attorneys here at DVAP, as we affectionately call ourselves. And this month, we will be learning all about driver's license restoration. Um, for those of you that are not familiar with our program, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their civil cases from start to finish, pro bono. We take a wide variety of cases from divorces, probates, expunctions, landlord-tenant issues. And one of the cases that we get a lot of requests for is folks that have lost their driver's license because they could not afford to pay their traffic tickets, and now they need help getting those tickets waived or community service so they can get their driver's license reinstated. And then once you get your driver's license reinstated, that opens the door for the people to get a job and provide for their families. So that's why we do this type of work. And we are blessed today to hear from Brittany Moore. She is definitely an expert in this field. She is a staff attorney here at Legal Aid of Northwest Texas, and I need to correct that. She is now the legal aid supervising attorney for the statewide expunction project, which is a new project that's just started. But prior to that, for several years, she ran the driver's license ID restoration project. She has done over 2,000 of these cases and gotten folks dismissals or community services waiving $620,000 worth of tickets so they can get their license. Um, she got her BA from Mid-America Nazarene University in Kansas and her JD from South Texas College of Law in Houston. And as she does her presentation, if you have any questions, please put them in the Q&A at the bottom. And at the end of the presentation, Brittany will try to get to as many as possible. And without further ado, I will turn it over to Brittany.
Thanks, Kristen. I don't really have much else to say, but let's just get started. We've got quite a few slides to get through. Thank you all for coming, and maybe I should push screen share first. That would help. All right. Kristen and Marcella, am I good? You guys can see the PowerPoint?
Yes, I can see it.
Yes.
Awesome. All right, so like Kristen said, I am going to be presenting today on driver's license restoration. We have an incredible need across the state of Texas. Tens of thousands of Texans do not have a valid driver's license for the many various reasons that we can have your license suspended. And it's not just tickets. The tickets are the large majority, and that'll be the majority of cases that are assigned to our volunteer attorneys. But there are a slew of many different other ways that a license can be suspended, and that's what we're going to kind of talk about. And then we'll go into what it will look like if you take a case from us and from DVAP. So why this work matters. More than 50% of the civil legal needs of the homeless population involves identification or an ID. Or a driver's license. This is a very basic need. They can't get access to benefits, can't get access to housing without identification, and obviously employment. More and more often now, employers are requiring someone to have a valid driver's license, one, to make sure they can get to and from work, of course, but then two, there are so many jobs that are available and more convenient for our client population that involve driving, and they can't get that without a valid driver's license. So very important work for the low income population that we serve. How these cases begin, well, we get an application, and then the client fills out that application either most of the time online through DVAP's online application portal, or they will come to a DVAP clinic, and they will fill out a questionnaire and an application. We then have our staff review their driver's license eligibility and failure to appear, basically just trying to determine what is your barrier to getting your license or ID. And then after that, we kind of break it out, confirm details, and then we send a list to DVAP, which they then advertise to you, and then you get to choose what cases you would like to take and which clients you would like to help. So how do we determine a person's issues or barriers with their driver's license? We start with these searches. Over here to the left, you'll see that driver's license eligibility page, and then to the right, you'll see the people call it the Omni-based website. This is what they're referring to. It's the failure to appear website on DPS's website. Both of these websites are run and operated by DPS, and they are both also free and accessible to the public. All the person needs is to enter their driver's license number, date of birth, and the last four digits of their social security number. Once you run both these search, you'll be able to pretty much see every single barrier that this person has that's keeping them from getting a license, which will include tickets, warrants, and or suspensions. And here is just a screenshot of what that eligibility page looks like. And again, this is a page that you will type in the date of birth, their driver's license number, last four of their social. And you'll see here to the right is a quick screenshot of what that page will then pull up once you type in a client's information. So you'll see here that highlighted section, it very clearly will state your license status is currently not eligible or eligible if it is in fact eligible. And then under that, it will carry on into a section that says compliance requirements, basically explaining why it's not eligible if in fact it isn't. And here is what that second page will look like as you scroll down on someone's eligibility page. This is just, again, an example of the many suspensions that DPS will have. But here to the right, this sample, this person had an SR no liability insurance suspension, as well as an SR suspension for a liability judgment. These two suspensions basically mean that they got into an accident and didn't have insurance. And then after that accident, the other driver's insurance company covered the repairs. So in case you didn't know what happens after that, this is what happens. They suspend the non-insured driver's license until they pay that judgment, because of course that insurance company that covered the damages then sued that person in JP court, most likely, and got a judgment, and that judgment is then sent to DPS, and DPS suspends their license. And that's basically what these suspensions mean. If you go to the column that says compliance instructions, you'll see where DPS lists the ways someone can remedy that suspension. So this is a really cool thing about this website is it doesn't just tell you it's suspended, it tells you why it's suspended, and even lists out ways that they can relieve themselves of this suspension. That being said, you might be wondering, well, why do they need attorneys? Why do they need us? Well, if you look at those compliant instructions, they kind of look like gibberish. And if they look like gibberish to you, I guarantee you to a client, it's a whole nother language. So what is SR22? What is evidence of a settlement or judgment creditor's consent to allow license and registration form SR84, right? Those are, or what is a certification of a dormant judgment? All of these things are things that some of us may know. And even if we as attorneys don't know we can find it somewhere, right? That's the biggest part of our job is research. And so that's why we want to take these cases. We want to help these clients because for us, it could be as easy as a quick hour of research, getting the forms, submitting the forms to a court, having them sign off on a dormant judgment, sending that to DPS. Really, we're probably spending more time on postage than we are anything else. And then that hold gets released. But as you can see where it says begin date and end date, that end date says 9999. So DPS is saying you will never have a valid driver's license until you relieve yourself of this hold. So clients will go decades with a suspended license because they just don't know how to do it, where we could spend 3 or 4 hours, lift this hold, and they finally have a valid driver's license. And that's what we want to do, right? We want to help them through that process as we, who are advocates, can do. And then this is just a final screenshot of typically the last page of that website. The last column is fees. So we get a lot of questions about these fees. These are called reinstatement fees. So when somebody has the suspensions that you saw on the page prior, excuse me, they'll have a fee associated with it. There are only 3 categories of fees with DPS, and you'll see on the screenshot the 3 different fees. These fees will never be assessed more than once. So if someone had a suspension that fell into the SR reinstatement fee suspension, they would only get that fee once, even if it was multiple suspensions under that category. But again, there are 3 categories. So they could potentially have a suspension under each category, meaning they will have all 3 fees. There will be no more than those 3 fees as well. There's only those 3, each one of them being $100. I think the highest is the ALR suspension, which is $125. These fees are not something we can do anything about. They are an administrative fee that has to be paid directly to DPS. Of course, if it's anything involving the court, normally we can do something about it, but this isn't a court fee or cost. This is just an administrative fee to DPS. So I always tell clients it's just something they'll have to pay. I would just pay one fee at a time because it can be paid online. There's a $4 convenience fee if they pay it online, but they can do that. I'm sorry, a $5 fee on this website. And then that's just what I tell clients to do, that they'll just have to pay it one fee at a time, if in fact they do have more than one fee, because there's nothing we can do about it. And then also another thing to note about these fees is they are just that. It does not render their license invalid. So if they have a valid license that was just suspended and you've lifted the suspension, it will then be valid again. But if their license has expired and they need to order a new one, they won't be able to, because DPS will not physically send them anything until these fees are paid. That meaning, just to sum that up, it doesn't render their license invalid. It's not a warrant, it's not a ticket, it's not something they're going to get stopped for. It's just a fee that they have to pay, and DPS just isn't going to send them anything until they pay it. So that's really the main consequence of not paying those fees. Enforcement actions. So as I mentioned before, there are 3 different categories of suspensions with DPS. The mandatory suspension is like its own classification, but it falls under department suspension when it comes to the reinstatement fees, the 3 reinstatement fees we just discussed. But here are the 4 different types of suspension. The ALR suspensions usually involve failure to take a breathalyzer. And just the denial, just the act of saying no will automatically produce a 90-day suspension, even if they would have passed it, even if the case is dismissed, even if it led to no arrest. And I think a lot of people have issues with that because they're like, how can they just suspend my license without any evidence or anything like that? And it's like, this isn't a court of law. This is literally an agency in Texas that just has this rule, and they're able to enforce it if there is reason to believe there may have been, that they may have driven above the alcohol limits. And that's their threshold, right? It's different than a court of law. And because it's their threshold, they can do it, and they will. They do it very often. Department suspensions, there's a whole list that I'll show you here in a second. Same with mandatory and SR suspensions. Again, SR suspensions are specifically related to insurance issues. So someone driving and getting a ticket for no insurance, someone getting into an accident and not having insurance, that's where you'll see an SR suspension. Enforcement actions continued. So this is basically when someone has one of those suspensions, but they keep applying to get a license, then you'll see one of these four things where it says DPS is just reminding you, hey, you can't get a license. And so they'll actually put it on your eligibility page each time they try or attempt, just so the person knows, and so DPS tracks the number of times they've actually attempted to apply for a license. Mandatory suspension. So here is a list of all of the different mandatory suspensions. Mandatory meaning there is a deadline, right? Like I said, the shortest is about 90 days or 3 months. And then the longest suspension you'll ever see when it comes to these mandatory suspensions is 2 years. So it can fall anywhere in between there. Typically, it'll be 3 months, a year, or 2 years, depending on what the suspension is for. And here is, like I said, an exhaustive list of all the different ways: boating while intoxicated, evading arrest, driving while license invalid, possessing more than one driver's license, that is an offense, graffiti, drug offenses, DWIs, and all these are just different ways someone can get their suspension. And by the way, if you want to look at these slides closer, because I will just be kind of going through them to get through the presentation, but they will be sent to you if they haven't already. Administrative suspensions and revocations. Here's another list of those different driver's license suspensions. Driving while license suspended, again, is another one. The biggest one is repeated traffic violations. So someone gets tickets often. Yes, DPS tracks that in a point system, and that point system will then eventually lead to a suspension. So you get one ticket every few years, you're fine. But you get one ticket every month, your license has probably been suspended. And so that's probably one of the most common ways to get these administrative suspensions. And then denials of driver's license. Typically, it's for physical or mental capacity. Or delinquent child support is another one. When it comes to physical or mental incapacity, that can sometimes be something the client knows or something they were unaware of. So if someone eventually gets several high-level drug or alcohol offenses on their criminal record, they can get a suspension from their driver's license. Why? Because the state thinks you're dependent on alcohol or substances, and it will inhibit your ability to drive safely. Is that crazy? I don't know. I'm just telling you the rules. And that is something they will see, right? Someone who gets 5 DWIs, or someone who gets felony level DUI, driving under the influence. Those are the people who likely have suspensions, and what they're basically medical holds, right? And DPS isn't saying you can't drive ever. They're just saying you can't drive until you send us a clean bill of health. So there's like a whole form and process that they would just basically take like this form to a doctor, and then a doctor would fill it out saying, yes, they can drive, they've sought treatment, they're good to go. But it also applies to physical disabilities. Someone's colorblind, so you can't see stoplights, that they would have a hold on their license. And again, as long as they get the right contacts or glasses, DPS will release the hold, but they need that letter from a doctor. So those are examples of those types of holds. Court ordered suspensions and revocations. Like I said, delinquent child support, that's another one I'll see sometimes. If someone's really behind in arrearages, of course, the other parent can often seek an enforcement, or the Attorney General's office will seek an enforcement. Once that happens, they will suspend your license until those arrearages are paid. We've had some luck in getting releases, or at least starting the payments, and then DPS releasing the hold. But yeah, it will be there until either one of those things happen. So I have seen that. interlock requirements, and like I said, mental incapacity and chemical dependence. We just talked about that. Failing to renew their registration as a sex offender, that's another thing. I don't know if you're aware, but of course, we require sex offenders who live in the state or move into the state to register every year with their new address. Even if it's the same, they still have to renew every year to make sure they're reporting their current address every year. So those are other suspensions you'll see on someone's driver's license eligibility. That being said, there are some holds, like I said, that have a hard deadline, and some holds that will last forever that might take time for us to relieve. In those situations, we can often get what's called an occupational driver's license or an ODL. ODLs are a restricted driver's license. So if we can relieve themselves of the hold in a decent amount of time, we won't even go that route. But if we can't, then of course we will go ahead and petition for an occupational driver's license. It's a very easy process in JP court. Sometimes they don't even require a hearing. And one thing to note about occupational licenses is it's not just for occupations. They do not have to be working to get an ODL. All they need to prove is a necessity. So they could be a single mom, they could be a student, they could be a homeless person who can't get a job because they can't get a license and get on the road driving legally. They could be taking care of elderly parents. They can use any reason to get any need to get an occupational license, but they do have to be prepared to prove that need, right? If they're homeless, give me a shelter letter. If they are actively looking for a job, maybe have an employer write a quick letter for you saying, I would have given him this job if he had a valid driver's license. Single parent, their food stamp letter is enough because it lists their children on there. So as long as you have a little bit of proof to prove that need, they can get an occupational license. Again, this is a restricted license, so often they have to keep a log that says where they go, when they go. Sometimes it's restricted to specific counties, like they can only drive in Dallas County, Tarrant County, and then they have to maintain SR22 insurance, which I will talk about in the next slide. But there are two different types of ODLs. The main and most common is the one I just talked about, the essential need ODL. So like I said, they just need to drive for whatever reason, prove that up, they can get an occupational license. The other one, which is less common, but is common in general, is an interlock ODL. Those are the people who've had their licenses suspended for DUIs or DWIs. One thing to note about these cases is they are more like a traditional case in filing. And that's because this is something that will have to be filed in district court into the case that suspended their license. Meaning if they got a felony DWI out of the 231st, you have to file this occupational license petition into the 231st. That being said, I like to do a little bit of legwork if I know this ODL is an interlock ODL, because some judges won't grant it, and for good reason, right? If this is their fourth DWI, no judge is going to put that person back on the road. And I will actually tell my clients that you do not want to waste your time and resources petitioning for something I know a judge is not going to grant. Because it's their, right? This judge is now responsible for putting this person back on the road that can't seem to drive sober. And that's just how they see it. And so we don't want to send a client down that road knowing that it's just not going to be a positive outcome. And so I like to do a little bit of that legwork. Oftentimes, when people come to us with this type of need, however, it's coming from their caseworker or probation officer who's like, they've been doing great. They're showing up for their programs. They're actively looking for jobs. They just need an occupational license. Those are perfect cases because the testimony of that caseworker is often how we're able to sway the judge our way if they're on the fence, especially in these situations. They'll, because they work for the prosecutor's office, their probation officers don't work for us. They, were court ordered. And so if the probation officer's there to say, oh, they've been doing great, judge, I recommend them getting this ODL, it makes all the difference in the world. So those are just a few background things I look into before petitioning for this type of occupational license. But it's totally possible. But again, just be realistic. If the client comes to you, tells you they've had 5 DWIs, off the bat, I already know that that's not something we want to attempt because it does cost a lot for us and the client to do something that we know is not going to happen. As I said a second ago, they are required to maintain SR22 insurance while they have the occupational license. So we petition, and before we petition, we have to show proof that the client bought the SR22, and then they still have to maintain it for the duration of the occupational license. So the ODL lasts for a year, 2 years. They have to make sure they maintain that insurance for that year or 2 years. SR22 insurance, if you're not familiar with it, is special insurance for basically people who don't have valid driver's license. It's exactly what it's for. I get calls all the time like, I can't get insurance because I don't have a license, and I don't have a license because I have tickets. And I'm like, well, that's what SR22 was created for here in the state of Texas. It's specially for that population. Some insurance companies charge more, some don't, some charge less. When I tell clients to go shopping for their SR22, I just tell them to shop because they'll get different pricings from different agencies. Almost every insurance agency that serves Texas, or I'm sorry, insurance company that serves the state of Texas has SR22 now. So they'll definitely get some good quotes as long as they just shop around a little and try to find something they can actually afford. Um, excuse me. After an occupational license order is granted. So we petition the court is like, yes, we will give them the ODL. Judge signs the order, and then you take the order. What do you do with that order? Are you done? No, you're not done. Can the client drive that day after the ink has touched the paper? Yes. They can drive that day with a copy of the order in their car, but they still need to send that order to DPS. They can only use that court order to drive for 45 days. Within those 45 days, they are expected to send that order to DPS and then have received a physical card that is their occupational license. So a lot of people who do this pro se, or even some attorneys who file on their behalf, they don't emphasize this enough. It is an absolute waste of time requesting this ODL if they do not do that final step. Because like I said, after 45 days, that court order means nothing. They can't just resend it later and be like, oops, I forgot. Can I still get my ODL? DPS is like, yeah, you can. You just have to petition for it all over again. So just make sure either you or the client are sending this petition to DPS with the $10 that's the cost for the actual card. And then DPS will send that back to the client's address. But again, they have to have that within those 45 days because that's when the validity of the order lasts and that's when it ends. If someone has had their license suspended for more than 2 years, they will have to take another driving test. So that's another thing I've had clients ask, because like I said, some of my clients, they've had their license suspended for decades. And while we're working on fixing it, we're getting them this occupational, but since it's been so long that they've had a valid license, they didn't realize they had to take the test again. Granted, the test is very different now. It's not like it was when we were teenagers. It's like just like this 6-hour online course. And they just have to pay for it, take it, complete it, and then they can go ahead and get their occupational license. So those are things just to keep in mind. If someone is getting an occupational license. Now, tickets. Tickets by far is the largest majority and portion of the cases we receive. And it's because they can't pay it. You can't squeeze water out of a rock. They are fine on the offenses. And it's the only type of relatively criminal thing we do other than expunctions and non-disclosures. And it's because they can't get a license without it. And we don't necessarily fight the tickets in these cases. We're basically just telling the court, hey, I don't know if they ran the red light. I don't know if they stopped or didn't stop. But what I do know is they can't pay this ticket, and they never will be able to. And so let's come up with another alternative. And that is the purpose of our advocacy in these cases. And so let's dive into it a little bit more. Why people can't appear? They can't afford it. I get judges who will sometimes lecture my clients as to, you could have just showed up. You just didn't show up for your hearings. You were scheduled to show up on so and so date. And my client's like, yes, I apologize, judge. And then judge will be like, well, why didn't you appear? And my response is, because they knew they couldn't pay. Like, I mean, for almost all of our clients, if they could pay, of course they'd show up. But knowing they couldn't pay, why would they, right? Because they think, I'm going to show up, I'm going to not be able to afford it, and they're going to arrest me. And that's why they don't show up. Is that true? No, there are other options. Are they aware of these other options? No, they're not, because it's not advertised as it should be. The courts just don't have it like blasted on their website or even on the courthouse doors. Hey, if you can't pay your ticket, you can get community service. Some people know it who have gotten it, but you will be surprised how many people, even to this day in the state of Texas, just do not know that there are other options to paying your ticket. If you can't afford it and it can prove to the court you can't afford it, there are other options. And so that's where we step in. How do we search for citations, dispositions? I've already talked about that, the two websites. And here are the actual links in this slide for those two websites over here to the left. Over here to the right, you'll see the different options that the court will present to someone who is indigent. They'll offer them a payment plan, deferred adjudication, time served, community service, or a waiver due to disability. And community service is calculated by a rate of $12.50 an hour. I'm going to talk more about each of these things as we go on. The failure to appear page. This is where typically, so earlier I showed you the eligibility page, which will show suspensions, revocations, administrative holds. This other website, again, the link is here to the left, will show their Omni holds, which are tickets, their fines and fees that they owe to a court. And here's a screenshot to the right of what that website will look like. The great thing about the website is it'll actually show the court's name, their address, phone number. They'll even show the cause number, the date of the offense, what the offense was, and then the most relevant thing to us, how much they owed that court. As you can see, this client owed $5,600 to one court and $3,775 to another. And to tell you the truth, that's actually not bad. Compared to what I have seen for some of my clients, this was probably an easier case because most of my clients are way underwater, and again, haven't had their license for decades. So it's not so much that they're committing these traffic offenses back to back, right? They got their first ticket when they were 17, and they didn't have $400 to pay that ticket. So then it became a warrant. It's now $800. They still couldn't pay that ticket. 2 years later, they got another ticket. And that ticket included a no driver's license ticket. So it started off 300, 300, 600. So now they owe, I don't know, I don't want to math, $1,400 total. And then they didn't show up for that one either because they're like, I still don't have that money either. So now that warrant, that doubles because of the warrant. And so on and so forth. The cycle just continues and never ends. So by the time they come to us, we clear it all. We help them clear all of those outstanding fines and fees. So that way they're kind of starting anew, right? You've got your license. We've cleared it all for you. We've helped you get a waiver, dismissal, or community service. You completed your community service. You've gotten your license. Just drive safely and then you're good. And then even if they get a ticket in the future, it's not overwhelming anymore. It's something they can actually handle. But by the time they come to us, it's spiraled out of control. And that is the purpose of these cases for us, helping them get back on their feet and restabilize. So a life of one of these traffic cases, they basically get the ticket, there's a pretrial setting, a plea or a trial, and then there's post-conviction. What happens in pretrial? If the client hasn't entered a plea, then they are considered in pre-trial phase of their ticket. During this phase, we can often negotiate with the prosecutor or even the judge, and we'll ask them for a dismissal, deferred disposition, and then the worst option is a conviction, but we can still get community service with that option. Do clients take that option? Yes. Do I recommend it still? Absolutely. Why? Because even negative points from a conviction will lead to a suspension that will end on an end date. And then we have two options. We can get them occupational license until that end date, or they wait it out, what some clients choose to do because it's not that long of a suspension. But at the end of the day, there is a light at the end of the tunnel. Whereas if they had to pay, again, the cycle would just continue. It would never end. And another 10 years will go by and they've still got these holds for these fines and fees. So even if they have to enter a plea, which I always recommend a plea of no contest, they will do that in order to just finally move on and move forward with these cases and these tickets. Post-conviction. So sometimes these tickets, the client has already entered a plea. Again, they just were never able to pay it. They might have entered a deferred disposition the time, where the prosecutor or the judge is like, oh, well, I'll reduce it to 300 from 400, saving you $100. So if you pay that in 30 days, then we'll dismiss the ticket. Great. But did they have that $300? No. But what did they tell the judge or prosecutor? Okay, sure. Again, because they don't realize there's more. They can ask for something else, right? They can ask and say, hey, I appreciate the offer, but I still can't pay that 300. Can I do community service instead of having to pay that 300 and I can still finish it in that 30-day deadline? That is something that the court will allow, but they don't even know to ask. But we do. And that is exactly what we will do in these cases. Here is an example of the template that you will be provided if you take a case from DVAP. It has this cover letter here to the left. I've actually made some tweaks to it to include some bond language. If you're ever asked to pay a bond, we're not going to pay a bond because our clients are indigent, and that should have been reviewed before requiring that bond. We will do an appearance bond for our client and for ourselves to appear if the judge would like a hearing. That's fine. We just won't pay cash. And we can't because they can't, right? So I've included some of that language in the cover letter. And then to the right here is the actual motion. It lays out the client's level of poverty, that they're homeless or indigent, why they need to get this driver's license. And then if they've served time, it includes a portion for you to add that in the motion in order for the client to get time served. Or if they're disabled, it even has a line for you to put that in the motion for the judge so they're aware that they're disabled for when they grant that finding of indigency. Of course, the relevant code sections and then your signature line. These next two pages are also in the template. It is the affidavit of inability to pay. This is how we're proving our client's indigency. We absolutely do our best to fill this out before we even give you the case. 90% of the time, it will be filled out before we give you the case because our staff has gone ahead and done it for you. Why? Because we have to confirm income anyways to meet the qualifications of our grant funders. And so why not kill two birds with one stone? While we're confirming their income, we're going to go ahead and draft this document for you so you can use it as Exhibit A, your evidence proving up your client's indigency. So this includes their basic information, but then also goes into whether or not they're employed, where they're employed, are they part-time or full-time, and where do they live? Are they homeless? Are they in a transitional shelter? Are they in a domestic violence shelter, a drug treatment shelter? We put all that, are they homeless or couch surfing? We put all that information in there so the judge is well aware of our client's situation. And then we start listing their wages or income if they have any. We go into their assets and then the money that they should be spending to pay for their necessities. What is their rent? What is their utilities? We even list if they get food stamps, Section 8 housing, all those details that a judge will want to know, again, in order to prove up whether or not they are indigent. Indigent meaning they are below 200% of the federal poverty guidelines. We list their dependents, any other outstanding debt. And then here, number 8, which is pretty important, I have a line that says the client is agreeing to allow us to enter a plea of no contest on their behalf if we need to, right? Of course, we prefer dismissal. But if we cannot get one, they've given us permission to enter a plea of no contest on their behalf. This is important because some courts will shoot you an email back once you file this and say, well, we need a plea before we can do anything. Oh, well, it's over there entered in the affidavit that the client signed and on penalty of perjury. So it's over there, line 8. You can look at it on Exhibit A. And then they're often like, oh, okay, I'll set you for pretrial. So it works out really well for those courts that like to shoot those back. So that way you can get your case moving. And then finally, we have a legal aid certificate, just reaffirming that this client was in fact indigent because they qualified for legal aid and DVAP. If they were not indigent, we couldn't even help them to begin with. And then finally, a proposed order. So that way the judge literally can check a box, sign it, and mail it back. We don't need to have a hearing. If you want to have a hearing, fine, but we really don't need one. I've submitted all the evidence you need about my client's financial situation in order for you to make this finding of indigency. Once the judge has made this finding, they'll be able to check a box that they dismiss, that they take the plea, that they waive the fine and fee, or that they grant community service, when that community service is due and how many hours are due. All that's in this proposed order. The judge can fill it out, sign it, and send it right back to us. And they do. I would say 70% of the time, these judges are just doing that, especially if it's further out. If it's a court in Dallas, just depends because they know you're in Dallas. But if it's a court outside of the DFW Metroplex, that percentage goes up to 90 when it comes to whether or not the judge will ask for a hearing. And then if the judge does ask for a hearing, you can always request for a remote hearing. Resolving omni holds. So as I said before, they typically get offered deferred adjudication time, but they can also request time served, community service, or a waiver of fines and fees due to indigency. Community service is pretty straightforward. Time served. One of the things I want to point out about that is it has to be in the state of Texas, number one. They couldn't have served time in Mississippi and then requested time served here for a ticket. And then number two, it has to be after the date for which they got the ticket. So they served time in 2012 and got the ticket in 2017. They cannot use that 2012 time to get credit for time served for that ticket. But let's say they got the ticket in 2017, but then served time in 2019. They can use that time and request time served for their 2017 tickets. Another thing to keep in mind is that it does not have to be time that's related to the ticket. So a lot of people think if I wasn't arrested on that ticket, I can't get time served. That's not true. You could have been arrested for an assault, for a drug charge, but if you were incarcerated, that is time you can credit to time served for a ticket. You do not have to have been arrested for a traffic offense in order to use that as time served for a traffic ticket. Community service. Here's a list of the different things that can also qualify as community service. You do, or at least it's good practice, want to request this at the beginning of your case. Don't just assume the judge will accept this because it is in the statute and the judge can take it, but don't just assume so. Some judges don't like that. They want you to specifically tell them, hey, my client's in a GED program. Is it okay if these hours can count towards their community service? A judge will never say no. Any one of these programs that's helping the client restabilize and get better and be more productive, a judge is absolutely going to love it and they'll be excited. They'll be like, can I see your certificate when you're done? And these are the things that qualify: any drug or alcohol treatment, counseling programs, GED programs, work and job skills. I've counted someone's college courses, anything that's really showing the judge that this client is actually trying, they can count towards their community service hours credit. Issues with community service. They do only get $12.50 a day, which can rack up, right? If the client owes $1,000 to that court, that's definitely going to add up to a lot of hours, especially if they owe more than that. I've had clients who owed 6,000, 7,000, and that's when the hours get into the hundreds, which is felony level. And frankly, that is something we're hoping to change one day. I definitely fight for reductions in those cases, and I'm often successful. But statutorily, they only have to grant a minimum of $12.50 an hour. They can do more, right? So just because the statute says they cannot go under $12.50 an hour, they can do more than $12.50 an hour. So let's say the client owes $2,000 to that court. A judge does not have to do a strict calculation. The judge can just say, you just have to do 10 hours. Dallas Municipal Court is really great about this. Their judge gets it, and he understands that it's really hard for clients to take care of this stuff. And so they basically only order 4 hours per citation. Doesn't matter how much the citation is, they just give 4 hours. So they can absolutely do that. There's nothing stopping that, but they can't do less, right? We want to make sure the judges do not order more against the client. But absolutely, if they want to give them less, yes, thank you. We appreciate it. Other issues is if a client doesn't complete, that happens. As an attorney, it is our due diligence to at least get to the point where we got that community service order. Once we've got that order and we provided it to the client, it is now up to them to complete those community service hours. We can't drive you. We're not going to follow you. We're not going to check on you each time you check into community service. You can do that because it's your license. You want it back, right? The onus has to be a little bit on them to at least do that part. If the client doesn't complete, again, you may not even know they didn't complete it, but you've done your job. You are no longer responsible after that. And it does happen every now and again, not often. I will say this, most of our clients do their hours because they understand how important it is to finally take care of this and get their licenses back. But for the times that it does happen, don't feel bad. You've done everything you were supposed to do and that you can do. I will say this, there are some clients who need an extension. If they need an extension, we absolutely can ask for one. I'm more than happy if a client communicates with me to go back to a judge and say, hey, judge, or just call a clerk and say, hey, my client, their kid was in the hospital for a month or 2 weeks or whatever. And so they haven't been able to finish their hours. Can we get an extension? That's fine. I'm more than happy to contact the court and request that for them as long as they communicate with me. But if they've just stopped speaking to me, stop returning my calls and emails, because I do send reminders about when their hours are due. But if I don't get any response and then they've not completed them, then I mean, that's it. I just close the case. But and then I advise them that if they want to go, themselves and request from the court a new order for community service, they can. Is it likely to get granted? Probably not, no. The best option they'll get after that is a payment plan. Undue hardship. So that's the waiver option. If I have a client who's indigent and the ticket is not eligible for dismissal, then I ask for a waiver under the undue hardship part of the statute. And the biggest reason I'll do that is someone who's disabled. I often provide proof of that disability in some way, shape, or form. You should too if you have a client in that situation. And then 99% of the time, a judge will say yes. I have had in my 2,000 some odd cases, only had 2 judges ever say no. And I was ready to appeal, but then they changed their mind before I could pull the trigger. So all that to say that it should never be denied. If someone has a hardship and like a disability, and you have proven that hardship to the court, then it has to be granted, especially if it's a disability, whether mental or physical, as long as you've proved it with either a Social Security note or a doctor's note. When it comes to work responsibilities, transportation limitations, or homelessness, that argument is more of a stretch because it's not so black and white as disabled or not disabled, but you can certainly make that argument, and I definitely would. Because if you're homeless and you're not already in a shelter, how are you going to get to wherever you're going for community service. You don't even have money for the bus or the train. And so those are the arguments you want to make in situations like that. Jail credit, we discussed that. It's actually increased recently to $150 per day instead of just 100 per day, which is what it used to be, which is nice, because that means a client could take care of a ticket just spending 2 days in jail. So I'm not encouraging my clients to go to jail, of course, but if they had jail credit that I could apply and request for on their behalf, they get a credit of $150 a day. I will say this, most judges are more generous. They could have served just a few hours and they'll give them a day's credit. Or they could have just served 1 day and the tickets like $600, they'll still waive it all for time served. So most judges are pretty generous when it comes to time served, but the statutory rate is $150 per day. Why are we able to do this? How in the world, Brittany, do you think you can walk into a court and say, you got to give my client community service and you can't make them pay? Because the law says I can. And here is that slide. You'll see here in the criminal code sections that are applicable, as well as the Texas Code of Transportation that also supports the criminal code section that basically is telling judges this is a problem. People can't pay, people can't pay. That doesn't mean you can't give them the ticket. That just means you need to give them another option to dispose of that fine or fee. And like I said, the law allows us to make that argument, and we certainly do on behalf of our clients. Again, you'll get these slides and this PowerPoint. So if you want to look into these code sections a little bit more, you're more than welcome. But I'm going to move on to the next slide. Here are the legislative changes and bills over the years that have only added more substance to this law. All this to say that the legislator gets it. It's pretty much across the board, actually. So do I get judges who give some pushback? Yes. But I think it's just a matter of educating them, not so much that they're against it in policy. It's more so just, hey, judge, they're literally never going to be able to pay this. Like, so for you and your court's sake, and my client's sake, give them community service, because you're just going to keep sending them letters and notices, wasting court time and resources, or rounding them up in a warrant roundup when they're still never going to be able to pay it. So I'm here to help us come up with a better option for this client. So this also covers so many other things, because they'll be like, oh, they already pled, or the case is in warrant status. Does that make a difference when it comes to indigency? No. If they can't pay, they can't pay. That's probably why the case is a KPS, or why the case is in warrant status, because they couldn't pay to begin with. So it went into warrant status. They still can't pay that because warrants double the price. So let's make it make sense. So that's basically what these changes and improvements to that code section have done, allowing for us, just adding more meat to this argument that we need to find other ways to dispose of this so people can get their driver's licenses, because it is absolutely a necessity, especially today. Case outcomes. Very quick work, very big impact. As I said before, we do a lot of the prep on the cases. We verified the citations with the court by the time you get these cases. Then when you get them, you just draft. And again, I provide you my templates. You have a mentor in Kristen. She will mentor you through the case as you work on it. I'm still not going anywhere, so Kristen can still send me questions as well. And I have seen not everything, but most everything. And so I can give you very specific advice if you have questions about a judge, a court, how to file something. You have access to us and that knowledge. And then you file it, wait for it to come back, and that's it. You're waiting for that judge to send back that order. If the judge requests a hearing, which, like I said, can happen, does not happen often, but can happen, then you just go to the hearing. And again, you're not fighting the facts of the case. You're just there to let the judge know my client is low income. My client is homeless. My client is disabled. That's what you're proving to the court. Not that's not them in the picture in that red light camera. You're just there to say they can't afford to pay. Here's the financial affidavit and other documents that prove that up. And it'll get granted. And then once the case is done, the client can finally have a driver's license. So that's what I mean by quick work, big impact. Should not take more than 3 to 4 hours for one driver's license case. That's how quick they are. And then, like I said, it makes this huge difference for someone to finally be able to get their license, and they're in their 40s, 50s, even 60s. That's the age range for my clients. And like I said, some of them have gone 10 years, 20 years, even 30 years without a valid driver's license. Most of them, not some, most, I would say, that have come to me are in that situation. And so you're making a huge impact on our clients' lives by taking these cases and relieving these holds. You also are covered through our malpractice insurance at the firm when you take a case with us. You are mentored, like I said, from beginning to end, and you have access to any of our training sessions, i.e. this one today, and training materials. Other legal resources, you have access to our practice manuals, other CLEs, and like I said, templates and expertise from our attorneys and paralegals who are always more than happy to help you through these cases. We do not leave you hanging if you take a case from us. The logistics, you'll sign an agreement with DVAP to take the case. They will send you the electronic file and all the information we've already piled up for you on behalf of the client and for the ease of the case. And then you have all their contact information. We let them know you're going to contact them and tell them to make sure they answer your call or reach back out to you as soon as possible if they miss your call. So they know to expect it and they're ready for you and waiting for you. So as soon as you reach out to them, then you can start working on the case. And now questions. Let me see if I can get back up there. What are the costs to a client for filing an occupational license? Well, I think the biggest thing is the SR22 insurance. So like I said, they don't just have to get the insurance, but they have to maintain the insurance. And insurance isn't cheap. It's going to be a few $100s at least each month to get that insurance. And I think that's the biggest cost because, of course, the filing fee is covered by a waiver for our clients. When we file these ODLs, they can get that fee waived. I have had judges want them to pay before, which was so odd. It's only like $50. But no, we will push back and say, no, you're not supposed to make them pay. The district courts know they're not supposed to make our clients pay when we've submitted an affidavit, but for whatever reason, with ODLs, I found in Dallas County, sometimes they ask about it, but I haven't had trouble having a judge grant that waiver for the filing. But yeah, the biggest portion of what they have to pay for ODLs would be that insurance. And again, they have to get that insurance before we can even petition. So that cost starts early on. And that's why I like to try to give them realistic advice as to whether or not it'll actually be granted. What is the mailing address to DPS where ODLs are ordered or mailed to? We actually provide that to you. It's in the template if you were to take an ODL. They now take emails as well. Well, take that back. That's for suspensions, not for occupational licenses. But there is a mailing address for DPS for those ODLs. We have a pro se packet that has that information. You can also find it on Texas Law Help or DPS's website will also tell you the address. I don't have it on hand right now, but if you really do need it, feel free to email me and I can send it to you. Let me go to this next slide. I think it has my contact information. And there it is. If you need to call or email me to get anything, feel free to do so. If a person has to retake the entire driver's license course, how much does that cost? I do not know. I've not had to do it, but yeah, unfortunately, I do not know the answers to that question. But I can find out. I'm sure it's on their website too. I do know most of the courses that I've seen online were like $27. That could have changed since the last time I looked at it, but I would say probably around that price is a safe bet between 30, 35, little more, little less. What if a person can't pay and can't do community service? That's where the waiver I discussed comes into play. As long as you can prove up that hardship, that undue burden part of the statute, then a judge should be able to grant a waiver of the fine and fee altogether, and they won't have to do either. And then again, there's also time served. It's another option for them not to have to pay or do community service if they have that available. But again, if not, then you want to really hammer in that undue burden argument. Is it filed in district court or county court? They're actually in JP courts and municipal courts. So Class C misdemeanors, your tickets are always going to be JP or municipal, right? Those lower level courts that handle Class C misdemeanors. And so that's where you will file the motion for finding of indigency. That being said, all those courts are not on e-file. In fact, most of them are not. I think Dallas JP's just barely got on there like last year. So I mailed all my stuff and sent it some sort of electronic way. So either the court's email or fax, in addition to physical mailing, is how I filed my pleadings with those courts. In fact, some of the courts, like specifically Dallas Municipal, requires you to mail it in. So those are the way that you would file those. But yeah, it would be JP or municipal court. Can the Omni fee be waived or reduced? Yes, it is specifically in the transportation code. It's in the slide that's in this presentation. But yes, judges can waive that. And I know they say all the time they can't. That's not true. They can absolutely waive that $30 Omni fee that DPS assesses against them. The reason they think they can't is because they're like, that's not our fee. That's a fee from DPS for us reporting the Omni fee. And yeah, I get it, but you actually can still waive that. So if you have a client who's getting a dismissal or a waiver, let the judge know so they can waive that $30 as well. Which is actually, by the way, supposed to be $10 now. It's not even supposed to be $30, but it just depends on the date of the hold. So most of my clients, theirs are older before that statute changed to $10. And so their Omni fee is still 30, but it's supposed to be 10 now, as of a year ago. I volunteer with the Homeless Day Center and have been clearing warrants track. Could have those individuals file with your organization and then I will be covered. Yes, you could. They could put in an application. Like I said, this is a project with Legal Aid of Northwest Texas and DVAP. So you can apply through any one of DVAP's method, which is one of their clinics, their online application process, or I don't know if they have a phone line, but I do know they have their online on their website, and there are many clinics that they do every month. And then you can apply through Landwid's process, which is any office's main line, our legal aid line, and our online application. Any one of those three ways a client can apply for this help and they'll get it. And then we also do provide pro se materials. So obviously sometimes we reach capacity, we can't take the case because we've got too many, not enough volunteers, so spread the word. But if that's the case, we also do have pro se materials where we provide the person with the steps and how to request community service or disability waiver or time served, and all that good stuff, as well as an ODL pro se packet. Did you say a client must have maintained SR22 insurance for a year before we can file a petition? No, 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 no. They do not have to have maintained it for a year before. They just have to have it before. So they could have bought it a day before I filed the petition, but I can't even file the petition until they've sent it to me. So, because it has to be included in your filing. You've got to have their driving record, which can be ordered online as long as they have the audit number from their license. You have to have SR22 insurance, and then of course your petition. So those three things are required when you file for that occupational license. But no, there's no like extended period of time before that they would have had to have it. They just have to have it when you file. And then they have to maintain it after the fact. So that's probably where you heard me say a year. If the ODL is for a year, they do have to maintain it for that year after they do get the ODL. How long does one need to maintain SR if they have an SR22 hold? There actually is no requirement. So I do tell my clients that if they have a suspension or hold for let's say they got a no insurance ticket, DPS puts a SR22 insurance hold on their license. All they have to do is get SR22 insurance. And I tell them to send proof of that to DPS, but really insurance companies are supposed to automatically send that. So when DPS gets that notice that they have SR22 insurance, they're supposed to release the hold. And they do. They do. As soon as they know that person got insurance, they'll release the hold. So really, there's no requirement to maintain it forever and always. Just get it, pay for that whatever 6-month policy that you got. And then after that, they can just have regular liability insurance like the state requires, but there is no minimum requirement. Do you have to have a program to help homeless gather their info to get their IDs, birth certificate, socials, and are there any resources for getting? Yes, there are actually. So another part of the work that we do is ID restoration, meaning it may not be a driver's license. They may just need an ID, period. I get a lot of those cases because one, DPS has real ID requirements now. People have gone just being able to change their name on their licenses for years, and then not had to prove it up. Now they do. And it could be something as simple as an extra O on their birth certificate, but they haven't been going by their name spelling with that extra O. It could be something that basic, but they have to come to us for a name change, and many other different ways. Some people have gone their whole lives without a birth certificate and didn't realize it. Some people didn't realize their birth certificate didn't have their first name. They were infant Johnson. So they came to us and was like, I need a name change to actually fix my name so I can get my ID. Anyways, yes, we can help with that. They can come to us and we will help them fix that and make all their ID stuff uniform. And that includes especially birth certificates, IDs. What happens is typically what we're doing is we're fixing the birth certificate issue. Then once they get that, we order that. They can take that to get their ID and then take that to get their social. Is there resources to pay for that? Yes, STUPOT. STUPOT absolutely has grant funding to specifically pay for those things. So if you have especially a homeless client who needs that, send them to STUPOT. Their caseworkers are great in working with those clients, and they also know to refer them to us if any of them have those issues. So please send them to STUPOT, Laura Anderson, if you have any clients like that.
Awesome. Thank you, Brittany, and thank you everyone for attending today's session. Just a couple housekeeping items. Yes, the copy of today's presentation will be emailed to you along with the MCLE course code, but I also give it to you at this moment. So that number is 174-270-685. Again, that is 174-270-685. And you should receive an email coming from Zoom with the link to access the PowerPoint, as well as just the course code for today's presentation. But we thank you all for attending today. Thank you, Brittany, for providing us a wonderful presentation. And if you do have any questions, please feel free to reach out to myself or to Brittany directly once you receive her contact information via email. Thank you so much, and everyone have a good rest of your afternoon.
Thank you.